Good morning. It gives me great pleasure to welcome you to our first of our webinars of 2022. It also happens to be my birthday. A lot of my friends are saying to me, I hope you're having a nice, relaxing day. And I said, well, yes, but I'm also presenting a webinar with my colleagues, Jonathan Mansfield and Angie Crush today.
Morning.
For those of you that don't know Thomas Mansfield, we specialise in employment law, obviously, family law, dispute resolution, and wills and probate. Now, in the employment team, we act for a whole host of employers, from owner-managed businesses right up to nationals and multinationals, and we offer all sorts of employment law support to our clients. Now, we thought we'd kick off 2022 series of webinars with a look at a topical subject that I imagine is at the forefront of everyone's minds at the moment, and that's returning to the office. And I remember, rather amusingly, we were looking at this in the middle of 2022 and thinking that we'd have an imminent return. And yet here we are, still grappling with some of the thorny issues. And in fact, I've had an email this morning from a client asking me about what to do when someone wants to isolate and can't come in, and the ramifications for pay. These subjects remain really relevant as we go into 2022. Now, we'll be considering place of work issues, including home and hybrid working. We'll consider managing vulnerable employees and those who are perhaps reluctant to return to the office, who don't particularly have necessarily any health conditions or so on, but are worried about it. We'll be weighing up the benefits of formal as well as more informal working from home and office working requests. We'll also be considering disability, as well as briefly touching on vaccination. We'll end the session with a couple of employment tribunal cases. There have been one or two which deal with COVID and its peculiar circumstances. Now, don't be shy. We really would like you to ask questions. So you can post those in the chat on the right of your screen there. Now, if we don't get to answer them as we go, then we will come back to them, or we'll endeavour to come back to them at the end of the session. Now, because we're covering a lot of complex issues today, it can be difficult to navigate in an hour. We'd love to extend the opportunity to you to have a one-to-one session with one of us at a time of your choosing. So we're going to extend that opportunity to you, and I'll let you know more about the details of that later on during the session. Now, I thought we could start with a poll. We'd like to know how many of you have returned to the office and on what basis. So I'm now going to put the poll up here, and hopefully there you can see the questions there. Let me know if you can't, and I'll give you a few seconds to answer. I can see, yes, okay, interesting. So we've got 33% at the moment, or 20% up and down a bit. Yeah, so it seems like the vast majority are working now on a part-time or hybrid basis. 23% on a full-time basis, and nobody, as I can see, won't be returning at all. I'll give you a few more seconds. So I think that then is very interesting and actually accords with my own personal experience of what my or what our clients are doing. And we're seeing significant return on a part-time or hybrid basis, minority on a full-time basis, yeah, so that sort of accords with my own experiences. What have you found to be the new normal, Angie, as we go through into 2022?
Yeah, I think the poll's interesting because it probably does reflect what I'm finding with my clients. I think some held off going back. They were ready to go back end of last year, but then they held off because of the rise in cases in December. But most have either already now mandated a return on a sort of hybrid basis, or are literally about to push the button to do so.
And what about you, Jonathan? Do you have anything to share with us?
I'm very similar. I think the general trend is towards hybrid. I mean, it's interesting going. We have an office in the city just near to the Bank of England, and going in there, the footfall is still right down. Especially Friday afternoons. Friday's one of the days I myself go in, It's almost dead at the moment. Whether that will change after the change of guidelines last week is a matter for conjecture, but I suspect it will stay rather similar. Reflecting.
Yeah, I think so. Yeah, I mean, people have got used to working from home, but also I think are keen to get back and have that that interaction with colleagues. And we'll be talking about that a little bit later, about the benefits of that sort of thing. It's really interesting to hear from you all about what is going on across the various businesses out there. So thanks to everyone for responding to the poll. Now, one of the questions we've been asked quite a lot is whether employers are obliged to vary working arrangements for their staff in light of the pandemic. Employers can put in place casual or temporary arrangements, but what do you think, Jonathan, about how we deal with more formal arrangements, contractual place of work, and mobility provisions, for example?
Well, pre-pandemic, most employment contracts would have one place of work specified, sometimes with a mobility clause, allowing the employer to change that one place of work if necessary. And if the employer wanted to exercise the mobility clause, it would be a case of assessing whether the plans would be an unreasonable exercise of that discretion. For example, if you relied on a mobility clause with a 50 mile a move to 50 miles away, it could be unreasonable and even in some circumstances lead to a constructive dismissal claim.
Okay, and what are we seeing? What are we seeing now in the sort of post-pandemic landscape? Well, the evolving pandemic landscape, I should probably say.
Yeah, well, it's open to employers to agree casual or temporary arrangements that are likely to be non-contractual, and this can be preferable as it gives employers greater flexibility and they're easier to amend or revoke. However, one of the contractual amendments that some employers are implementing is a specific provision requiring employees to work from home. And this is helpful for future pandemic proofing. And of course, we don't know what's going to happen with the arrival of new variants, things like that. And it also makes it easier to initiate disciplinary proceedings if an employee refuses to work from home, or for setting a framework for other disciplinary or performance issues, such as not working from home in a reasonable manner, and if there are concerns about the employee's productivity. One of the other contractual amendments employers are utilising relates to hybrid working arrangements. Some employers are specifically setting out how many days a week their employees can work from home and how many days they're expected to be in the office. Although this may seem overly formal, some employers are reporting a real push from employees to achieve contractual commitment and certain working arrangements, and particularly at the recruitment stage, that this is coming up when I suppose the employees have a bit more, feel they may have a bit more negotiating power. But on the other hand, from an employer's point of view, it could well be that it is a sales tool to attract and retain talent, to be able to offer the hybrid working arrangement. And I should say again, referring to our own firm, it's our experience over the years and well before the pandemic that we've always found it a fantastic way of attracting talent to our firm to be able to offer flexible working.
No, absolutely. I mean, yes, and I second that. It is a real benefit. I've been talking to individuals recently who've made it known at interview that that's what they would like to do, and also it's been offered the other way as well. Well, thanks, Jonathan. And although a word of warning to employers who are wanting to insist on employees working from home, you have no idea what their setup is. The idea is someone working at their kitchen table and they just get on with it. They could have a house full of people every day, dogs barking, children, friends, adults at home overhearing everything they're doing. And you won't be able to complain about these things if you force that person to work from home when they wanted to come into work. That's perversely, I suppose. Angie, what have your clients been feeding back to you now they're starting to return to the office?
Well, unsurprisingly, employers are reporting an increase in flexible working requests since requiring employees to return to the office. And it seems that employees who perhaps previously might not have come forward to make a flexible working request are now doing so. Historically, you tended to find only people who had, childcare or other caring responsibilities would make the request. Whereas I think now everyone sort of finds it acceptable to make a request just so that they get a better work-life balance. But that's not to say that an employer has to acquiesce in all cases.
Okay, so what should employers consider then when they receive a flexible working request? Can you take us through that?
Well, first of all, they should consider the various types of arrangements and what is it the employee is asking for. Is it a statutory request which will result in a permanent contractual change, or are they asking for something a bit more informal? Now, there are risks in refusing flexible working requests, such as constructive dismissal and sort of indirect discrimination claims. So it is important to have a clear and rational reason to refuse when hybrid working arrangements have been successfully utilised throughout the pandemic. And I think it's useful for employers to have a checklist of points to run through if they are considering some form of permanent remote working. Which if I run through these points. So first of all, consider whether you need to change or tailor employment contract clauses to encompass home working, hybrid working, and whether you either need to introduce new policies or review existing ones to set out the arrangements and conditions for home working and hybrid working, data security, all of these things. Also, and I'll talk about this a lot more later in the webinar, but taking appropriate measures to protect confidential information and data. This is going to be a big one, I think, if you're moving to permanent home working, even if it's on a part-time basis. Reviewing health and safety implications, also deciding what equipment you will provide. So it was one thing when this was a temporary arrangement. This is now going to be sort of set in stone as a permanent arrangement or pretty permanent, then you need to address your minds to what's your policy on what equipment are you going to provide. Are you going to provide two lots, one for in the office, one for at home, that sort of thing. You need to think about insurance requirements potentially, and also how to properly manage and supervise people who are working remotely for at least part of the time. And then also identifying potential tax consequences of home working and hybrid working. Certainly we've seen some clients, discover that one of their employees has decided to, in some cases just move quite a way away. In others have even moved abroad or been working from abroad. Now that potentially has tax implications. And so you'll need to think of all of these depending on where people are going to be working from.
And I've experienced that as well with, I think, someone moving to Australia without telling their employer, and then someone else, I think, moving to Greece as well. I know you've been considering with one of your clients the pros and cons of formal contractual flexible working changes. That's sort of set in stone, as it were, versus informal hybrid arrangements. Can you explain this for us and maybe look at some of the benefits and disadvantages of that?
Yeah, of course. Firstly, it's worth saying that a major concern employers have is loss of skills and learning. And this isn't a concern for the immediate future, but it's a concern for the mid to long-term future, because it's become pretty evident that the main way employees develop, learn, and become an integral part of the business is by the information they absorb in day-to-day life in the workplace, as opposed to going on a formal, training course, whether it be a day's training course or a webinar or something. A common comment that we are hearing from typically sort of mid to senior level employees is, they don't need to go to the job to do that. They can completely do their job from home. And can't the employer just trust us to get on with it? Now, that may well be the case, of course, that they can completely do their job from home. But, how are all of the others and new people in the team or junior people in the team going to learn to do their job as well as that person, unless they get a chance to observe and listen and interact with them on a daily basis? not even that, how do others in the business even come to know, who does what within an organisation where you're not physically present together for some of the time at least. There's an anecdote I heard, which I'm going to share with you because I think it can give HR managers the sort of perfect response to some employees who come up with this argument. And it relates to, it was actually pre-pandemic, this was, and there was a set of barristers' chambers that had a debating competition. And the theme of the debate was whether the set of chambers should go virtual, with all of them working from home every day rather than going into the barristers' chambers to work. And in this case, the junior barristers were tasked with arguing for remote working, and the seniors, and a QC was representing them, was tasked with the going to work argument. And in the debate, the QC representing the seniors said to the junior, well, what would you do in this scenario if you had a question on a point of law, you wanted to run it by someone, or if you wanted to know how a particular judge, dealt with cases of a certain kind, or what their approach was, or you wanted to just test an argument on someone? And the junior said, well, I would just call you up. And the QC turned around and said, well, no, you wouldn't, because you wouldn't know who I was. And I thought that was a really good summary of the risks if we fast forward 5-10 years, because if there isn't togetherness in the office, and in talking about this, you also have to consider the people who, if you've got one person in on a Monday and one person on a Tuesday and one person on a Wednesday, that probably doesn't work for the business either. So I thought that summed up the risk going forward quite well. The second thing that I've been looking at, as you say, is flexible working in the traditional sense of the word versus hybrid working. Now, my general approach with employers is to tell them to be quite cautious to committing to anything in the long term, because we haven't had any long-term testing of remote working in normal times. Now, in the lockdowns, all the shops were shut, all the cafes were shut, schools were shut, you weren't allowed to go out and meet anyone. You were pretty much confined to your home for long periods of time. And it's only really relatively recently that some normalities returned. And I feel that employers perhaps need to spend a couple of years to enable meaningful comparisons to take place around things like productivity, employee cohesion, and what works for the business. So I think there needs to be a period of monitoring, which is why I'm suggesting caution in agreeing to anything permanent. So one of my clients wanted to return to the office, wanted at least 3 days in the office. And what they thought they would do initially was to ask everyone that didn't want to come in full time to make flexible working requests, submit them all by a certain date so that they could consider them all together. And they felt that was the fairest way, rather than looking at them piecemeal as they came through, which would allow them less flexibility for the last person making their request. And they could ensure that business needs were met and just look at everything together. On discussing, what they were trying to achieve with them, I suggested that perhaps, they could start off with just a hybrid working arrangement, which, wouldn't bind them to contractual commitments as much, and would mean that they could review and adapt it as necessary going forward. And ultimately, this is what they've decided to do.
That's very interesting. Actually ties in with the question that's just come in. Thank you for the question. It's nice to see that people are posing questions here. So the question is, we're having a hybrid working trial. If at the end we decide to carry on with hybrid working, can we leave the contract as office-based and run the hybrid working as a separate policy in case the business needs to change the parameters in the future? Yes.
It sort of ties in with what I'm probably going to talk about is if you are going to work in a hybrid manner, how to do that.
And it's a question of whether that then varies the contract. But I think if you've got the place of work in the contract as the office, you could have the hybrid working policy as a non-contractual policy. The contract is likely then to trump the non-contractual policy, and that would give you the flexibility you need, I think. I don't know whether you agree, but the non-contractual policy is not likely to then oust in terms of the express term of the contract with the place of work being the office. That would be my thoughts on it, provided you make it clear that the policy is not contractual and that it's at the employer's discretion, and those words are very clearly highlighted in the policy.
Yes,
it's at the employer's discretion. So it might seem counterintuitive to have both, but as I say, provided the policy is expressed to be non-contractual and discretionary, then that should be sufficient, I would have thought. And you'll fall back on the contract if you want to impose office-based working. I don't know if you agree with me on that.
Yeah, I'll go into a bit of detail on this perhaps in a moment.
Yes. Well, thanks, Angie. And can you talk us through some of the issues surrounding a more concrete framework? I mean, not all employers will want to have this sort of informal arrangement and might want to have something more fixed.
Yeah, and I think that's, perhaps what the question is alluding to as well. There's sort of, you want to have something there, but, and I think there are definitely steps you can take to maintain structure and appropriate behaviours in the same way as you would if the people were in the workplace. And if you're going to go down the road of non-contractual hybrid working arrangements, I would strongly suggest implementing a hybrid working policy from the get-go, as opposed to simply letting remote working continue in an unmanaged way. So I think that's definitely the way to go, because then you can address the very fact that this is not binding on us. This is subject to review. This can be changed. The default position is still what it says in your contract, that you are office-based or workplace-based, whatever the nature of your business is. The policy that I've prepared for the clients who have wanted to use it so far tends to assume there will be a minimum number of days they're required in the workplace per week. The specific days will be agreed locally with their line manager, and they may be subject to change or review. So, for example, if there was a particular Tuesday that the line manager wanted everyone in for a team meeting or something, the employees under that policy are required to exercise flexibility, and everyone would be expected to go in on that particular day. And importantly, you can build review periods into a hybrid working policy. And that's good as well, because it also forces employers to look at the setup from a business point of view, make some comparisons, do a survey, see how staff are feeling, etc., on a regular basis. Without those review periods, what tends to happen is it just gets allowed to sort of continue, and there's no sort of trigger points to make sure someone's actually reviewing if this is working. One of my clients had particular issues with people taking breaks during the day, their sort of normal working day, that hadn't been pre-agreed. And now this might be, that's not to say they weren't working the hours they needed to, but for example, swapping out a lunch break at standard lunchtime to perhaps be able to collect their children from school or something like that. For some employers, this will be a problem, but for others, and for the couple that I've dealt with, for some it won't be a problem, for some it will be a problem, because for some, they need people to be available at certain times, and there's an expectation that they'll be able to pick up the phone when they receive a call. So that's one area that has needed addressing. And it's also become apparent that a couple of employees were looking after their children or responsible for childcare during their core working hours. Now, it's understandable to some degree that employees see one of the benefits of home working as, having an opportunity to save money on childcare. And of course, in the early days of the pandemic, there was no choice because schools were closed and all children were at home. But in this case, it was having a detrimental impact on my client's business, they felt, because This particular person had younger children, and they were regularly around and needing attention, and the employer could sense that they weren't able to give their full attention to business matters when the children had returned home from school. So as such, again, we tackled this head on, included provisions in the hybrid working policy, making it clear that it's not acceptable to be responsible for childcare during core working hours, and that they should use the same sort of after school arrangements or whatever as they would have done had they been at work, which still gives them the benefits because they don't have the commute time, but just setting out it's, we want you to be fully focused on the job when you are working. We got employees to all sign up to say, yes, we are happy to accept these conditions as part of this arrangement, and that will make it easier for them to discipline or speak to them about this if there are problems again in the future.
I think that's a really helpful example because it shows how things have organically changed over the last couple of years, and people have sort of not taken liberties, but lives have fused with work because of the nature of the way in which we are working now. Now, as I said at the beginning of the session, because we're covering quite a lot today, we're extending an opportunity for you to have a one-to-one complimentary consultation with one of us. Details of how to register your interest will be on screen in a moment. And I'll keep that posted until the end of the session. And hopefully there you can see that, and you can register your interest there. And by all means, do contact us after the session as well. Now, thinking about some of the other practical implications employers need to consider when bringing employees back to the office. Jonathan, can you give us an overview of where we are currently and what your clients are most concerned with?
Okay, well, there have been quite a lot of important changes to COVID legislation and government guidance of late, and these will affect how employers deal with the practicalities of returning to the office. The main thrust of the changes has been the removal of all remaining legal restrictions. Until the 31st of March, government guidance advised those testing positive for COVID to continue to stay at home. But now people with COVID symptoms are encouraged to exercise personal responsibility in a similar way to those who have other contagious diseases. This is likely to cause issues for employers, as there will also be almost certainly be instances of conflict with the employees in their because people's views on isolation are likely to differ. Also, the COVID provisions within the statutory sick pay legislation have ended. So COVID is no longer to be treated differently to any other illness, and employees are now subject to the usual 3-day waiting period before SSP kicks in. And this is likely to put some employees in certain types of job off isolating. So it's more likely that you'll have COVID positive employees attending the office. Again, this could cause conflict for employers if they favour employees staying away from work, but employees don't want to take the 3 days unpaid sick leave. And it may also lead to accusations by other employees of a failure to protect their health and safety. Employers may wish to consider amending any contractual sick pay provisions or policies to cater for their isolation wishes, while avoiding any action which could be discriminatory or lead to possible claims of constructive dismissal. Also, from the 1st of April, free COVID testing largely ended, and employees are unlikely to want to pay to test in order to attend work, especially if their preference is to work from home anyway. And some of the prices for testing that I've been tests now it's no longer being provided are quite high. So you'll need to consider whether you wish to provide tests to employees and what to do if the employees then refuse the test.
Yeah, okay. And we've actually had an excellent question in, which ties in quite nicely with this. Where do we stand with employees who inform us that they're tested positive, who state they want to work, so they actively want to come to work? And they're well enough to, but we, the employer, want them to remain away from work to protect other people. What is their pay entitlement effectively? So do we have to continue paying them full pay? as they want to work, but we're stopping them. Well, I can answer that, I think. Where an employee is ready, able and willing, and that's actually lifted from the statute, those words, ready, able and willing to work, and are able to perform work in accordance with the contract, then there is an implied term that the employer has an obligation to pay wages, unless there's a contractual right not to do so. I think it'd be very unusual for there to be a contractual term like that. You could attempt to argue that they're not able to work because of the risk they pose to colleagues. But of course, that's you, the employer, placing your own determination of risk on that scenario. And when, as we know, the government, as Jonathan's just said, have relaxed the situation in relation to self-isolation. So I think, as regrettable as it may be, consequently, I think you are going to be obliged to pay the individual full pay if they're testing positive and want to come to work, but you don't want them to. So that's something that's going to be quite, I imagine, a thorny issue for people going forward. And Jonathan, what about risk assessments? We've heard quite a lot about them, but questionable how many of us have actually carried them out and on what use they are. Perhaps you could talk to us about that briefly. We've lost Jonathan. Jonathan has gone on to mute, I believe. We're not too tech savvy. I think Angie's going to be talking about tech savvy home working in a moment.
I am.
We may have lost Jonathan, but we shall see in a moment. I am ably prepared to carry on for him if he's not able to get back in.
Maybe leave and come back in, Jonathan, and we'll carry on without you.
Yeah, we'll carry on. So Jonathan has left the room. Well, there's no longer a requirement for every employer to explicitly consider COVID in their risk assessments. And I was saying before, I wonder how many of us actually have. The intention being to empower businesses, apparently, to take responsibility for implementing mitigations that are appropriate in the circumstances. And this is that sort of light touch approach that the government have suggested. But remember that employers are still subject to general health and safety obligations set out in the Health and Safety Regulations 1999, and of course the earlier iteration, the Health and Safety at Work Act. As well as that, employers have a common law duty, and this is that sort of rather nebulous, woolly idea that we have a duty to take reasonable care for our employees. It's also an implied term of employment contracts that employers will take reasonable care of the health and safety of employees. So this is going back to that question: should we require people who are symptomatic and testing positive? Should we require them to stay away from the workplace? And you've got this obligation, of course, to provide a safe place of work for everybody. So I guess the question then is what to do when an employee raises concerns about health and safety. They're potentially also protected from unfair dismissal and detriment and dismissal. And we've had another question which ties into this. After the changes effective 1st April, what should we be telling employees if co-workers get COVID? Well, the rather unhelpful government stance at the moment is that it's down to individual discretion. But it really depends on, I think, the nature of the workplace, how many people are in the office, and the ramifications of what would happen if more people get it. If people are able to work and fit enough to work and maybe have mild symptoms, then you might take the view, practically speaking, that those people can come to work but take precautions, so wear a mask or that sort of thing. If they're more severely ill, well, they may not be able to come in anyway, but you might be saying to those individuals, stay away, because then that has that impact on pay. I don't know if anyone else has any thoughts on that issue.
I think as well, it doesn't necessarily depend on how bad their symptoms are, but because you have to think about what the risk to other employees are and how bad their symptoms might be should they catch it, which of course is pretty much a complete unknown, because some people who are seemingly healthy and well get quite sort of bad symptoms. So I don't know of any employers who are permitting people with COVID to come into the workplace. And sort of going back to the earlier question about pay, I think if employers don't pay people who are coming in, who aren't able to come in, because the employer has said they don't want them to, you will end up with a situation where they simply don't say that they've got COVID if they actually feel fine, and will just come in and infect anyone anyway.
Yeah.
A sort of
Yeah,
follow-up question
point,
is whether the rest of the team need updating. I'm assuming you're perhaps thinking about if they've already been in the office with someone who's got COVID. And it's a difficult area because on the one hand, health information of this type is sort of sensitive personal data, which can't just be distributed willy-nilly. But on the other hand, you do probably need to tell everyone else who perhaps has been in the office that they need to make sure they're testing before coming in. Certainly this is what I find most people are doing, testing before they come in, just to make sure that they haven't caught it off of the other person, but are, for example, asymptomatic.
Yeah. I think it's a courtesy to let other people know. Then you do have this sort of snowball effect of people then not coming in, and you hit upon something quite important there, which is this disincentivizing people if you're sending them home.
Yeah. I think Jonathan's going to perhaps talk about sort of testing and paying for testing.
We've got a question there about the testing. I mean, you're not obliged to pay for the test as an employer. You're not mandated to do so. But it's this point about, I suppose it's a bit churlish of the individual not to pay if they think they've got it, and they're potentially putting others at risk. I'd be inclined, if I was the employer, probably to pay for the test, get them to test, and then take a view on. But then you can't compel them to test either. It's the difficulty. So it's a fraught area. But we'll maybe come back to Sarah's question in due course as Jonathan talks you through. The points that Jonathan has mentioned will be relevant to all, actually I was talking wasn't I, but will be relevant to all employees, I think, these health and safety obligations. Are there any particular points especially relevant to vulnerable or the clinically extremely vulnerable? You did touch upon it just then, actually, and the effect on others.
Yeah, I mean, although the clinically extremely vulnerable shielding programme officially ended 15th of September last year, and the government guidance states that the sort of vulnerable people are now considered to be well protected, at least from serious illness, after the vaccination programme. So they're being advised to follow the same guidance as everyone else, but it's not as easy as that for employers who can't just simply disregard someone's vulnerable status. All employees who have a disability have protection under the Equality Act, and it may be that an employer's provision, criterion or practice of requiring all employees to continue to attend work could be indirectly discriminatory against a disabled employee if they cannot justify it as a proportionate means of achieving a legitimate aim. There are also risks of other types of discrimination claims, such as discrimination arising if someone is disciplined or even dismissed or not paid for refusing to attend the workplace as a result of their sort of vulnerable status, if that arises from a disability. And then there's the obligation to make reasonable adjustments, such as, could they perhaps put a vulnerable person in their own office if in an otherwise open plan office, to sort of make some adjustments so that it's safer for them to come in if they're going to be among other employees. Yeah.
We've also got the issue of long COVID as well, and this sort of unknown quantity there.
Yeah, I mean, I think long COVID is definitely going to be a problem for employers. I already have one client with an employee. Actually, the employee was only taken on November last year, got COVID in February, and has been signed off already until June. So this is going to be a problem area. And the Office for National Statistics says that by the end of January, just gone, 1.5 million people, or 2.4% of the population, this is in the UK, said they were still experiencing ongoing COVID symptoms more than 4 weeks after first infection, and 45% saying they were still experiencing symptoms a year or more after infection. And the list of potential effects, according to a professor from Imperial College London, are wide-ranging, over 200 potential effects: heart palpitations, brain fog, microscopic lung damage. And so employers are going to need to consider on a case-by-case basis whether people who are perhaps taking persistent or long-term sick leave, or perhaps aren't performing as well as they previously had prior to having COVID, whether they could be suffering with long COVID, and whether that might be a disability in their case, before they take any action.
I mean, I think if someone is exhibiting a difference in approach to work, or their productivity isn't the same as it was before, and that they've had COVID particularly severely, you might well be on notice. And this is a question of then the obligation to make adjustments and so on, having knowledge of disability. How should an employer deal with an employee who has severe anxiety? Moving on to that sort of non-disabled necessarily category, Jonathan, and who's afraid to attend work.
Yeah, well, it is likely to depend on whether the anxiety is likely to amount to a disability under the Equality Act. Where it doesn't, employers may wish to be reasonably robust in enforcing return to work or other pandemic-related provisions. And I would emphasise the reasonably point in there, because the anxiety will be very, very genuine in many cases. But talking through it with people, consulting with them, is likely to be a good way of handling it. Anecdotal evidence suggests that many had mild anxiety about returning to the workplace, but it seems to have subsided once they've got back into the routine of going. For those with more serious anxiety issues, medical advice should be sought as soon as possible from a specialist treating that employee, or from occupational health, to determine whether the employee is disabled and to see what adjustments might be reasonable and relevant in those circumstances. And the key aim is going to be to try and keep employees continuing to work. An example could be that an employee with severe anxiety has their condition exacerbated by the process of travelling to work. They may have a concern about being in public places, particularly when masks on public transport and things like that are no longer compulsory. ACAS has produced guidance which suggests that an employer could offer extra car parking in certain cases, so that those employees could avoid using public transport, or maybe to temporarily allow them to work different hours to avoid peak travel. And so on. So if the employee's anxiety prevents them attending to work, it's possible they may be regarded as on sick leave, and therefore will be entitled to sick pay and SSP or contractual sick pay. But if you can find a practical way of avoiding that, clearly that's to the advantage of everyone. Okay.
And what about the reluctant worker? I'm thinking of people who aren't disabled necessarily, otherwise. Those who purely have a preference for home working. I think they're going to have a more difficult time of asserting that they have the right to do that.
Yes.
But what are your thoughts?
Well, it is a tricky area, and I'm certainly hearing of plenty of cases where employees are expressing a reluctance to return to the office, even on a hybrid basis, because home working's provided many benefits, such as increased family time and saving on commuter costs. What action the employer takes will depend on the circumstances and will need to be assessed case by case, with different employees' own circumstances warranting different considerations. For example, it's going to be much riskier to require a disabled employee to return without any adjustment than a non-disabled employee. it will also depend on whether the employee's role can be carried on from home, and if so, how effectively.
Okay, thanks. I mean, I think employers, as I say, are probably going to be a little less tolerant to the merely reluctant. Angie, you've advised a client recently about this, I understand, who appeared reluctant to work, but only when it came to attending the office. And can you talk to us about that and how the client was able to overcome those problems?
Yeah. First of all, just touching on what Jonathan said. With a sort of genuinely anxious person, and one other adjustment I've seen to try to make it more palatable to them, for them to come to the office, is to have a bit more of a robust testing process with other staff members. So really trying to make sure, that everyone tests. I think some places have a far more flexible approach. Others, there's one firm that I know of who sort of almost have a COVID police in there, and if you haven't uploaded your negative test in the morning, they'll be at your desk asking, where it is and have you done it, and can you go and do it now. The client that you're referring to, I mean, I act for a firm of architects, and this was earlier in the pandemic. And they decided that they really did need people to be in the office a couple of days per week, because in-person collaboration was necessary on, on drawings and projects and that sort of thing. But one particular employee said, they wouldn't come to the office for longer than 2 hours at a time because they didn't want to risk using the sort of toilet facilities or the kitchen facilities. They felt it was all too high risk, and so they were sort of pushing back on coming into work. Now, this wasn't realistic or feasible for my client, who really needed people there all day collaborating on the projects that needed collaborating on in person. And one of the reasons they were able and felt confident in taking a robust approach to sort of simply saying no to this person was that they knew the person had in their sort of personal time been on holiday to Cornwall, which, given the proximity from where they lived, would have been sort of 8-hour journey. So they must have had to use public facilities in that period. They were aware that they had been out socially, that sort of thing. So in that case, they simply said, no, this is a requirement. And actually, once it's sort of going back to anecdotal evidence, but once they were back in the swing of it, it all settled down and it turned out to be fine.
Yeah, I think that's often the way that you get people together and the anxiety dissipates somewhat. But another area that we're seeing issues with in the context of home working is protecting an employer's confidential information. And I think, again, you've advised a client recently on data security and confidentiality, and perhaps you can outline some of the key points for us there. And I think we've got another question, so I think we'll come on to the question afterwards, if that's okay.
Yeah, I mean, I think confidentiality and employers needing to consider protecting their confidential business information is going to be really key, because I can see this being a problem area. I've seen a few cases in a relatively short period of time recently where this has been at the crux of a sort of disciplinary investigation. To sort of summarise one of them, there was a case where an employee who had a work laptop but had a much bigger personal computer screen had sent an email with some sort of financial reports to her personal email to be able to view it on a larger platform. And to cut a long story short, this person was then sort of dismissed for gross misconduct for breach of the IT and sort of system security policy. The email did contain potentially confidential information. But one of the issues in this case, and this is what I want employers to think about, is that the same organisation were completely overlooking other breaches of the very same policy. Now, these breaches were things like, so for example, the policy would say, you can't let anyone over here, anything that you're saying. You can't, carry paperwork. You can't have paperwork outside of the office, that sort of thing. But in calls, team calls, client calls, that sort of thing, you could see people walking past other people in the background. On some occasions, they might have their partner sitting next to them, also working from home. So there were daily breaches of the strict letter of these IT and security policies. And the fact that employers were completely overlooking certain breaches of the policy, yet dismissing for gross misconduct other breaches of the policy, meant that the employees were really uncertain as to, well, how are we supposed to know? And this is how the argument will go. The dismissed employee will say, how was I supposed to know that particular one you were really concerned about, but you were happy for other people to be privy to the entire day's conversation on a daily basis, and we're happy for that one to be completely overlooked. It's really inconsistent, and employers will start to get in trouble if they start to be selective on which breaches they will and won't tolerate. So you really need to think about your policies. How does that work with what's happening in practice with the way that people are working remotely? And what should you do to try to make sure that your information is confidential? That's one area that I think employers really need to take a look at if this is going to be a more permanent working arrangement.
I think so. And it also might be, sorry.
I was just going to say one other sort of point to mention is employees not always being as tech savvy as employers seem to assume, because employees have had to cope with a vast range of new IT applications to use over the pandemic. And aren't always, really tech savvy people, knowledgeable about how these apps might integrate with other systems. So I've also seen situations where, for example, employer data has somehow integrated over OneDrive or something like that with an employee's data on their computer. Just because the employee didn't really know, you get messages pop up, do you want it to do this? Yes, no, click this. People just click on things without really knowing the implications of that. And you're going to need to invest some training in, the tech stuff if you want to make sure your data is secure and people aren't inadvertently putting your information security at risk.
And I think that's really important. That there's just been this tendency to just get on with it, as it were, and you can't have it both ways as an employer. On the one hand, you're reminding employees that policies apply, but you've got to make it possible for them to be able to comply. It might actually be a reason for you to insist on people coming back to work. We are running a little out of time, but I wanted to come to a question. Those whose role cannot be conducted from home and therefore don't receive the benefit of hybrid working, do we need to consider those? I think it's a question of the implied term point about treating people reasonably. But I guess the question is getting at the idea that those individuals who can't work in a hybrid way will feel in some way disadvantaged. I don't know if you've got any thoughts on that. I think it's really a question of taking each case as you find it. If they can't work from home, they can't work from home. But that doesn't mean you've necessarily got to make everybody work in the office. I don't know if you've got any sort of other thoughts on that, John.
No. I think it can be problematic if you end up with a two-tier workforce, and certainly some employers have that in mind. But it does come down to the nature of the role. Some admin tasks just can't easily be, or not they can't be done from home. It's more productive for them to be in work, and ultimately that's the test. It's not, can we manage to have it done from home? It's, is it better for us if it's done in the workplace? And if the answer to that is yes, then you can justify that, asking that person to come in. And it's unfortunate, but that's the nature of some jobs.
And it's certainly there's certain sectors other than those where you've got to be there and customer facing or whatever. Sales roles and things like that are typically lean towards having people continue to come in all the way through. Depending on guidance at the relevant time, and I think the two, like Angie said earlier about perhaps this is a reason for not a company committing itself completely to allowing hybrid working or home working, willy-nilly, and there will be a period of getting used to this new culture and what works for the business, avoiding the two-tier thing.
Yes,
showing flexibility where appropriate, but bearing in mind what the needs of the business are.
I just wanted to touch very briefly on topic of vaccination. Conscious we're sort of under 5 minutes now, but given the government's U-turn on the healthcare workers, which I think we're all slightly surprised by in vaccination, it seems to me that requiring staff to be vaccinated could well be problematic. Jonathan, just if you wouldn't mind just giving us your thoughts on that briefly, and then we'll move on to we'll have maybe just one of the cases that you were going to talk about.
Okay. Well, with the blanket mandatory vaccination policies are likely to be unlawful, was the verdict of the Human Rights Commission back in April 2021. So even in certain sectors like the care sector, the government has stepped back from that, although there will be particular guidance for that. So I think employers should be very careful to consider whether it's appropriate to prevent workers from attending the workplace who aren't vaccinated, and it's unlikely to be appropriate, I think.
Yes. Okay. In terms of the tribunal case, we'll have a look at one, I think, which is quite interesting.
Yes.
Maybe shows the mood of the pandemic early on about how employers were responding to it. This is a case of Quelch and Courtiers Support Services Limited. If you could just outline some of these.
Yes, that's right. I mean, this is the case of somebody who worked as a compliance analyst for a provider of financial services and lived with his girlfriend who suffered from asthma and a heart condition and she was classed as clinically vulnerable. He discussed his concerns with his manager and was allowed initially to work from home, but then later the employer took the view that the employers were critical workers. This is a provider of financial services, so it seems a little bit strange that they took that position. He repeatedly, this is the employee, raised health and safety concerns, but his request to continue to work from home until the guidance on home working changed were refused, and he was advised that the only option was to take unpaid leave, annual leave, or sick leave. He was then put on unpaid leave when he refused to return to the office, and eventually he was dismissed for gross misconduct. The tribunal found that it was an automatically unfair dismissal, and that he genuinely and reasonably believed that there were circumstances of serious imminent danger were he to return to his office. And this, of course, is one of the key rights in the Employment Rights Act, protections, which has been used quite a bit during the pandemic by employees and has thrown up some interesting cases. Whether the outcome will be the same with a change of guidelines is an interesting question, and certainly a lot of these cases that we've heard have been first instance ones, and ones in the very particular circumstances of the early pandemic. So it will be interesting to see how the case law evolves from now on as well.
And there is another case of X and Y, which was to do with whether fear of catching the virus amounts to a philosophical or religious belief. But of course, it doesn't. You'll be pleased to know, certainly not in that case. Well, the topic certainly seems to have engaged us, and we've had far more questions than we could have hoped for, and that's been wonderful. If you do have any employment-related queries, please do get in contact with us, and you can find our contact details on our website, thomasmansfield.com. Now, we'll be back at 10 a.m. on Thursday, the 19th of May, with a webinar on attracting, recruiting, and retaining the right talent in 2022. And we're really excited to announce that we have Chris Rofe from Lockton Employee Benefits team joining us to talk about how leading employers within a wide range of sectors are addressing recruitment challenges by strengthening their employee experience and reward strategies. And that's a bit of a mouthful, but it sounds very interesting. and it'd be great if you go to our website and register your interest. Now we're just within time, and so it's time for us now to say bye-bye, and we really hope to see you again at the next session. Thanks so much for joining us, and we look forward to seeing you again in the future.
Thank you. Bye.